Hello, everyone, and welcome to the Summer of ISHQ, a six-series conversation brought to you by the Center for Studies in Gender and Sexuality at Ashoka University. My name is Madhvi Menon, and I'm Professor of English and Director of the Center at Ashoka. The Summer of ISHQ is a hot extension of our flagship speaker series, ISHQ, which as a word in Hindustani translates into love, desire, passion, and as an acronym, Issues in Society, History, Queerness, allows us to theorize and politicize that passion. As I said before, we're doing this over a series of 6 webinars. We started last week with a session on rights that was discussed by Judith Butler and Ratna Kapoor. A recording of that session is available on the CSGS YouTube channel page, however, whatever the language or the right terminology is. And today we're doing our second session on the law. And I will introduce our speakers and the question in just a little bit. And to tell you, we're going to move on after this for the next 4 weeks with sessions on politics, on cinema, on borders, and on education. And also to say that the format for all these sessions will remain the same and as follows, which is that each of our speakers will speak for 10 minutes at the beginning, addressing the topic and the question at hand in whatever way they see fit. They will then be in conversation with each other for another 10 minutes. Following which we will have 30 minutes of Q&A with questions from the audience. And so you will see at the bottom of your screen a Q&A button. Anytime between now and the end of the session, please write in whatever questions you have. My only request is that you keep the questions as brief and succinct as possible, so we can take as many of them as possible. And we'll do that for the last half hour of the session. Our question for today is, can the law be feminist? A question that, as I said, can be as broad or focused as our speakers and our audience would like to make it be. And our 2 wonderful speakers for today, Arvind Narrain, who's an advocate and a founding member of the Alternative Law Forum, and Jyoti Puri, who is the Hazel Dick Leonard Chair and Professor of Sociology at Simmons University in Massachusetts. And the question, can the law be feminist? We'll begin by hearing from Arvind. Arvind, all yours.
Thank you, Madhvi. And thanks, Jyoti, for being a part of this conversation. The question of, is it possible for the law to be feminist? I think, for me, it'd be phrased too broadly and too widely. I'd put it very differently and say, is it possible to bend the law towards feminism? And by this, I mean that, how do we think about the law? That's really the point I'm getting to. And for me, we think about the law as a space, which is a space for struggle. It's not a space which is completely occupied by patriarchy. It's obviously not a space completely occupied by feminism. And I want to try and illustrate this in some ways through a very concrete illustration of the 17-year battle against Section 377 of the Indian Penal Code, 17-year legal battle against Section 377 of the Indian Penal Code. And the fact that the battle itself, or the struggle itself, or the movement process itself contributes to a certain kind of a jurisprudence, which is really the end point of the struggle. So in a sense, if you want to put it more broadly, Professor Bakshi says somewhere that rights are really products of people in resistance and communities in struggle. So I really like to make the point that the end point of the 377 battle, or the one end point of the 377 battle, which is the Navdeep Singh Johar judgment in 2018, is really an outcome of really this of people in resistance and communities in struggle, and this is really around the country. And I want to make the legal battle obviously starts in 2001, and the formulation initially is around one formulation. One of the legal formulations is really around the right to privacy, and I want to look at a little more closely at the right to privacy itself, because I know that there's a very strong and for very, very good reasons, a very strong feminist critique of the idea of privacy itself. Because privacy, if you look at the jurisprudence around it, comes from the idea that the man's home is his castle, and if a man's home is his castle, can give rise to a whole range of abuses and violences. And if you look at judicial decisions, law commission reports, look at the 172nd law commission report. What is their argument? Their argument is that that marital rape can't be interfered with because it's excessive interference in the realm of the family. So you get a sense of how the family or the family is walled off from a possible intervention because it's a part of the private sphere. And that's really where the feminist critique, in a sense, is coming from. So when the right to privacy was presented as an argument, the strongest critique and the strongest response we got was from our feminist colleagues and friends, in particular from the group called Labia in Bombay. And their entire point was, privacy makes no sense to us. It's a deeply patriarchal notion. We want nothing to do with it. Why putting forward an argument based on privacy? And similarly, from the transgender groups at that moment in time, and the lower class in terms of the gay community themselves, their point again was, privacy is all very well for you. You have a home to go back to, a nice bookshelf sitting at the back. But what about us? We live on the streets. We have to have sex on the streets. We don't have privacy. We don't have a zone of privacy. So what sense does it make to us? And so I'm just illustrating the fact that this was a very strong critique which came. And in a sense, we had to go back a little bit to the drawing board, as it were, and think of, how do we think about this notion called privacy itself? And we went back, actually, we found a very fascinating judgment by the South African Supreme Court, called the National Coalition case, which was their decriminalization decision. And there's a very, very interesting concurring opinion with Justice Sachs. And he makes the point. He says that when the intervener in this case made the argument that he said that the decriminalization should be on the grounds of equality, not on the grounds of privacy. And the way he put it, they see privacy as a poor second prize. And he went on to say that, there seems to be a doleful subtext that whatever you do in the privacy of your bedroom, how bizarre it may be, it's fine, and that's the argument on privacy. He says, but that's not the way we should see privacy. We should see privacy as linked, in the sense, to dignity and linked to equality. And the argument he's putting forward, I think, is an interesting point, where he says that privacy might be, one is the zoning notion, second is the notion which is linked to autonomy of decision making, and third is the link to dignity. The link to dignity is because when you're talking about your decisions you make about your intimate life, about who you choose to be with, that's really a part of your right to dignity, and dignity is integrally linked to privacy. The second argument on autonomy, again, is that it's clearly a part of a decision you make about who you want to be and who you want to be with. And that's, again, a part of your right to autonomy. So the inflection to privacy was linked to both autonomy and dignity. And Nas took that forward and saw privacy not as a freestanding concept, but privacy is linked to autonomy and dignity, put forward a very different notion of privacy. And it's interesting for me that the critique of privacy, which was there prior to the judgment, was not there post the judgment, because people saw the fact that the judgment incorporated some parts of the critique into the thinking itself. And of course, the story doesn't end with Nas, because Nas, of course, led on to it's very interesting that Nas, in a sense, led on to which is actually cited by the 9-judge judgment of the Supreme Court, which again looks at privacy as a part of the fundamental rights chapter. And finally, of course, Navtej, which also looks at privacy as a part of the fundamental rights chapter. And make one last point about privacy and move on to the 3 other concepts I want to quickly highlight. So if you look at the notion of privacy, I think there's the dimensions to privacy which are incorporated in both Navtej and both Puttaswamy. One is privacy as sanctuary. When you say privacy as sanctuary, it's a space where the way the judges articulated, you can let down your guard and be yourself. And if you want to give a literary analogy to this, I think the best analogy is this book by James Baldwin called Giovanni's Room, where the idea of, what is the space which allows you to be who you are, to develop your own sense of personhood. And as far as the author in this case is concerned, it's the room which he spends with the Italian waiter called Giovanni, which allows him to develop his sense of selfhood itself. And that's this place sanctuary. Second, if you take the question of dignity, again, you don't think of sex in the context of dignity. And what the judge's contribution, what the judgment's contribution is to say that we need to think of the question of the decisions you make about your intimate life as linked very integrally to the question of dignity. That is, if somebody interferes with your right to decide who you want to be with, if the state interferes with that, that's really, in a sense, it's a casting a pall of humiliation on who you are. Nobody has a right to disturb that sense of selfhood and personhood which you have. That's really the right to dignity. And the third argument the judges make is, of course, the entire question of autonomy, which I've already spoken about. And the fourth one, which I want to quickly mention, is the idea of what Justice Chandrachud calls the right to heterogeneity. Again, that's very interesting because I think links up to the entire question of artistic creativity itself. Because the argument the judges put forward is it's only a zone of privacy which allows you to develop your own sense of expression, selfhood, artistic expression, how you choose to put it. If you're not in conformity with your family, with your society, it's that zone of privacy that allows you to develop who you are. And I guess you can think in terms of the Virginia Woolf room of one zone, different ways in which that zone allows you to be who you are in contrast or in counter to the demands of society as put forward through as put forward by institutions such as the family, for example. That's one point I want to say about how the law is bent towards an imagination of privacy, which is different from the initial conceptualization of zonal privacy, which is linked purely to the idea of a man's home as his castle, as it were. The three other notions I'll quickly highlight. How much time do we have, Madhvi? I can't hear you.
You have another minute and a half.
Oh, minute and a half. Okay, fine. Minute and a half. I'm going to just say three more points. Maybe I won't get a chance to elaborate on each of them in great detail, but I'll just mention it. Second is linked up to Madhvi's point of ishq, is the Navtej Johar's articulation of the right to love. And again, this is I think it's a contested issue, but I put forward the opinion and welcome any critiques and comments, which I'm sure there are many, of the idea that the right to love in the Indian context is a deeply revolutionary act because people get killed for loving across the lines of caste and religion. And the judgment recognizes that, where Justice Chandrachud says, the right to love is not just a right for the LGBT community, but a right for all of us. Because it's a way in which we begin to challenge societal, not we, but people who love across lines of caste and religion, challenge structures of caste domination and gender domination. That's a very important dimension. The third quick point I'd make is the development of the idea of non-discrimination and the idea of stereotypes as limiting your sense of expression. In Article 15, the judges say that the problem with 377 is the language of unnatural. What the language of unnatural does is transitions from the law to societal ways of thinking and perception. So if a transgender person goes to a police station and is treated animal-like, that comes from the perception from the law, which translates into wider society. And so the way of thinking of sex is not just sex, but stereotypes, which limit your right to expression, is a very, very important development which should be taken forward in non-discrimination law in times going forward. And the last point, I'll end with this, is the idea of constitutional morality. The judges Naz invokes constitutional morality, as does Navtej Singh Johar. And constitutional morality comes from Dr. Ambedkar, who makes the point that constitutional morality is not a natural sentiment. It has to be cultivated. And that democracy in India is a topsoil, is a top dressing on a soil which is essentially undemocratic. And the point which Dr. Ambedkar is making, the very important point, is in India, we don't just have a form of state tyranny, we also have a form of societal tyranny. And we have to fight against societal tyranny as well. So in a sense, what Navtej acknowledges and recognizes is that the struggle is obviously not over. The struggle has only begun because the struggle is laying in place a normative framework, and the normative framework basically is something with which we have used to combat and fight societal ways of thinking. I'll give you one last illustration of this. Very recently, we had a judgment of the Uttarakhand High Court, which was basically about these two women who were in a relationship with each other, and whose family found it intolerable. And so the family took one of the women back to their home, as it were, and didn't allow her to come out. So the other woman filed a case, a habeas corpus petition, asking for it produced before the court. And the judge in his judgment actually makes the point, says that these women are adult. They have a right to live their lives as adult persons. We can't interfere with the fundamental freedom who they choose to be with, who the marital partner is, And that judgment, though the judgment doesn't expressly invoke Navtej, is an outcome of a change in a certain kind of societal climate. But it's not enough, of course, because again, one last invocation, if you go back to Navtej and read Justice Nariman's judgment, he makes the point that there's a long way to go. He says that the central government and the state government must do training programs, must popularize the judgment with all the means at their disposal, and must also have training programs to ensure that the police officials are trained on the substance of the judgment itself. So the understanding is, if you take the idea of constitutional morality, that we have begun the journey of transforming attitudes and behaviors in the Indian context towards a mode of greater understanding of the right to life dignity and privacy of the LGBT community. But that's a beginning point of this journey, not the end point of the struggle, as it were. I'll end it.
Thank you, Arvind. Jyoti, I'll call upon you. You'll need to turn on your mic.
Sorry. Okay. Thank you so much, Madhavi. I'm happy to be here, and many thanks to Ashoka for hosting me. And really lovely to be here in conversation with Arvind. And Arvind, thank you so much for laying some of that out for us in these useful ways. And I think it's such a provocative and interesting layered question, really, that you're asking, Madhavi, about whether law can be feminist. And immediately I want to be able to open up both the question of what is law, in the sense that is it symbolic structure? Is it a set of meanings that really define our personhood, our relationships, who we can be with, under what circumstances? Is it about this kind of dominant consciousness, this dominant collective consciousness? And after all, law as we know it, as we understand it, really comes from a context of colonialism, imperialism, civilizational projects that are then embraced by post-colonial states such as India, right? And I think it's also about the question of, are these the rules that govern us, that shape our lives, that tell us what to do and what we cannot do? But also the matter of, in a sense that as rules, they have inequalities built into them. They are not equal. They are not equally extended to everybody, which is why I think Arvind then makes that very powerful point that law becomes a site of struggle, precisely because of the inequalities that are built into the system. I also then want to, just sort of put a question mark in terms of feminism. What do we mean by feminism? How is it different from women-centered projects, right? And then, considering we are looking at all of this through the lens of Section 377 and the struggle to decriminalize it, it raises the question of queer perspectives, trans perspectives. Are they in line or in conversation or even perhaps in tension with feminism, right? So I think it just opens up that really interesting and complicated set of questions. So as I think about this, and I want to come at that question about law and feminism, I want to begin with the issue of what is the purview of feminism, right? What is its purpose? What are its values? And is it really about gender inequality? Is it about, dismantling structures of social sexual control and regulation? Is it about dismantling caste structures, religious majoritarianism? And I would make the argument that it is about all of this and more. So then I think the issue is that if feminism, or for that matter, queer and trans perspectives, are really about the reorganization, a fundamental reorganization of our social fabric, then it seems to me that law is one dimension, an important dimension, but not necessarily even the primary one. So to then move this perspective to the terrain of Section 377, what I would like to do in the next few minutes is highlight 4 points of tension, dilemmas or conundrums that I think were really shaping this struggle and shaped it over the course of its duration. And I think in many ways will continue to persist even after this. As Arvind was saying, the struggle has just begun. This is the first step. This is not the final step in terms of LGBTQ, HKI rights, right? So the first point of tension that I want to mark really has to do with the issue of engaging law, but also the limits of legal campaigns. So in one respect, the fact that we had a law such as Section 377 introduced by the colonial state that was then held over and carried forward into the post-colonial state, it's there. How can you not engage it? It's there as a symbol. It's there. It is being used on the streets. It is being used for harassment, forms of violence. And so in one sense, you cannot sidestep it. The law is there, and it's also as an impediment to all kinds of other rights that might be possible. And at the same time, the conditions under which law became the focus of social change, of changing attitudes in terms of Indian society, that was also the moment in which there was a fair amount of attention on the global and the transnational scale as far as decriminalizing anti-sodomy laws. If we recall, this was also when the HIV/AIDS pandemic was making its impact felt around the world, including in India. And I think one sort of more point about why law became the focus at that point has also to do with the fact that it was 2001, and after liberalization in 1991, the terrain had actually, the social terrain had started to shift in important ways, so that increasingly law and legal change, or what Nandini Sundar has called law struggles, became the primary, or at least an important avenue for creating those kinds of social changes that were desired within the Indian context. So if there is this pressure on the one hand to engage law, on the other hand, there are these critiques coming from, particularly from groups that straddle both the feminist as well as the queer in places like Mumbai, like Labia and Saheli, that are immediately questioning the turn to law as the instrument of social change. And their critiques are coming from these long-standing understandings and analysis, feminist analyses, that sometimes legal change can be important and it also can be strategic, but it's not enough. By itself, it's not going to have the kind of impact that we would like to see, the wide-ranging impact on the ground, and that the most effective kinds of social changes come when they are from the ground up, right? And one last point about sort of the feminist critique of this focus on legal campaigns is that even when we get positive legal changes as a result of feminist or other kinds of struggles, these legal changes sometimes have unintended and even negative consequences. So those are some of the things that I think we need to keep in mind when we think about that relationship between law and feminism, or trans or queer perspectives. Second point of tension that I want to really note here, and I won't say too much about it, because Arvind has been talking about the issue of privacy in a helpful way, but the tension has to do with working within the constraints of parameters that are already set by the law. So in a sense, you have to conform your arguments, you have to conform your petition, you have to work within the structures that are already provided by the state. What is going to be legible to judges? What's going to be persuasive to them? So not surprisingly, and to a degree understandably, initially when Naz made the argument, or even ABVA had entered the first writ back in 1994, and both of these writs, these petitions around decriminalization, were about public health hazards that are created by suppressing homosexuality or pushing it underground, right? And then again, the right of privacy, because I think the initial concern was that this would not be palatable to judges, without that particular specification, without that particular caveat. And yet, as we know, that privacy is also a factor of privilege of all kinds, and having that. But, as I said, Arvind has really helped us also nuance that argument in ways that we can talk about. A third point of tension that I want to note is that between the letter of the law and how it is interpreted on the ground. And for me, one of the most troubling points came when, over and over again, when I was talking to Delhi police, they would associate Section 377 as being a law about regulating sexual deviance. And in their minds, this is something that is associated particularly with Muslim men, who they see as much more prone to this, much more prone to deviance and licentiousness, to excesses. And this is contrary to any kind of evidence. All of it, in fact, is telling us very, very differently. But still, that was the thing that they held on to, and it was very consistent. And my point here is that Section 377, which seems to be on the surface a law about sexuality, about same-sex sexuality, ends up implicating religion and, in fact, caste and gender and class, so that it's, it forces one, or to be effective, we have to think expansively. And the last tension that I'm going to talk about is that much as Section 377 was the impediment, was the barrier, was symbolically troubling, materially troubling on the streets, it is one among many such laws and policies that impact people on the ground. And hijras, for example, kinnars, Aramanis are much more likely to be booked under the anti-trafficking provision than they are under 377, or public nuisance, vagrancy laws. And part of that is because there is this deeply seated understanding that they are much more likely, they are prone to criminality, right? So even as we've happily seen the demise of Section 377 as the Antisodomy Law, at the same time, it raises for me the question about the challenges that still continue. And I think here of the Trans Rights Act and the ways in which it hasn't really done much in terms of extending trans rights, but it has increased quite significantly state administrative bureaucracies and state authority on people's lives. So I think with that, I'm going to just end it here, and perhaps we'll pick up some things in the Q&A.
Great, thanks so much, Jyoti and Arvind. These were such rich and provocative openings. This is wonderful. I just want to sort of throw one question out there just to hear you both in conversation with one another, and then we'll start taking questions from the audience. I'm really struck by how both of you actually did a really good job of thinking of the question itself as both expansive and focused. And I'm wondering what you think about, because that's exactly what the law is, right? On the one hand, like, what is vagrancy? What is against the order of nature? I mean, what are all these vague, capacious, huge terms that can then be used very specifically? So I just want to hear the two of you speak very, very quickly and briefly about what that relationship, what that tension, what that enabling tension maybe is between the non-specific and the specific in relation to laws about sexuality. Either
Go
of
ahead,
you. Yeah, Arvind. You'll need to turn your mic on. Yeah, you're on now.
Bhagvi, I'm sorry, I'm not too sure I fully got the question. You're saying what's the connection between the norm and the practice?
I mean, sure. I mean, if that's how you would like to address it. I was actually thinking about just picking up on something that Jyoti said when she said, you have to sort of frame your resistance to the law within the structure the law gives you. But the law actually gives you such a capacious structure that when you frame your resistance to it, you're framing it in a very particular way. And so what that relationship is was what.
No, that's a good question. Perhaps we can illustrate that with a very specific example, right? Again, getting back to the question of privacy and the way the jurisprudence on privacy evolved in the Supreme Court. If you see the first decision where privacy is articulated, it's really as a challenge to what you call domiciliary visits by the police at night, right? Karakani and Govind were really about that, And it's interesting, again, you see the point of the capaciousness of the law comes through, because what the judges are really articulating is that you have a right to privacy in the sense that you have a right to freedom from domiciliary visits by the police at night. But in doing that, they've drawn a conception of privacy which is much broader. So, for example, Govind really makes the point that privacy is really also about a space where space of home, where you're right to let down your guard and be yourself, right to be let alone, which is the American formulation, which they take and they borrow from, right? And that right to be let alone, in that sense, transmutes again in terms of NAS, where the right to be let alone becomes not just the right to be let alone in terms of a abstract, disembodied citizen, the way the judges put it, but really a right to take forward your own personal project of self-discovery and self-creation, as it were. That's where NAS goes towards. So they see the question of, how the right to privacy is really linked to the notion of dignity in that sense, right? Mm-hmm. So there's a way in which privacy, which begins as a zonal notion, takes on a different kind of a flesh and blood, as it were, and as it circulates through the system. And it takes on a dimension of dignity, it takes on the dimension of autonomy, and takes on a dimension of self-growth and self-fulfillment, as it were, right? So it ends up fulfilling a range of other possible ways of thinking about it. So I think you can do that kind of an analysis with respect to, say, dignity as a concept, right? Dignity emerges in the context, again, if you take the first case Olga Telles, in the context of Francis Corelli Mullen, in the context of prisoners' rights. Yeah. And from prisoners' rights, we get to the domain of sexuality. From sexuality, we get to the domain of of not being put down on the basis of a caste name, right? That's equally as for dignity as opposed to humiliation. So I think each of these notions, you can see how they develop, right, in terms of the law. Yeah.
Okay. Thanks, Jyoti.
Madhavi, it makes me think of a couple of things. One is precisely because of the terms that are already set by law and the challenges to the law. So you can have this, and you can have, the Nafte Johar judgment is, in fact, they really are trying to do right by queer and trans and gay people, right? And that's an important judgment. But precisely because of the workings of law, that we are held bound by them, you can't, they simply can't say that not only are we decriminalizing homosexuality, but we're saying that every right that is entitled to somebody else who is not gay or not queer or not trans is now extended to everybody, right? So in other words, you have to go piece by piece by piece. Workplace discrimination, we've just had that be, finally upheld in the context of the United States. So it's this kind of piecemeal approach. And then one of the things that we know from long experience is that there are all of these loopholes that continually appear. That sort of, the specificity of all of this. So in one sense, the point then is that the work of legal change, of legal activism is never done. It's a lifelong process because you're always going to be, it's always about this needs to be fixed, that needs to be fixed, this needs to be, we're always going to be caught in the minutia of legal change as opposed to be able to really think more broadly about what justice looks like.
Right. Thank you both. I'm going to hand you over to Alankrita now, who will be asking you succinct questions, and my request would be, in the interest of time, that you keep your answers as succinct as possible as well. Alankrita.
Thank you both. That was very insightful. We have quite a few questions, and I'm trying to accommodate at least 5 of them. The first one is from a student at Ashoka, and he wants to play with the title and overturn it to ask the panel, is it possible for feminism to be legal? Is it possible for feminism to be reduced to a set of principles and normative guidelines? Or is feminism fundamentally anti-normative? And either of you can answer that. Or both of you.
I think it's a really interesting play. And I think, we do have legal feminisms in the sense we have lots of examples of them that are really not only in terms of narrowly constituted, but these are, what some scholars have called governance feminisms, right? In terms of that are really about somehow legislating each and every piece of this. When we think about questions of sexual harassment, sexual violence, sexual control, somehow that, that law is the chief, the primary ways to address all of this. And so I think we have examples of legal feminism. And I think we also have much critique, and I think I certainly share that critique of these feminisms that are really constituting themselves narrowly and are continually being pivoted toward the state.
Yeah, no, I guess if you think of the law as a set of principles, the way you articulated it, it's important also for feminism to be legal, in the sense that if you're looking at the principles of which we've been talking about, you're looking at principles of say dignity or principles of say equality, they're fundamental. Again, why they're important both in terms of principles as is mechanisms is because we have to locate this struggle in the context of the fact that society is fundamentally unequal. And our challenge is not really to the state, it's not beginning with the state. State is not the sole locus which we're concerned with. Our concern fundamentally is with the inequalities in society, right? And we're going to address the inequalities in society. What role does the law have to play? And that's the question we have to ask ourselves. And I think if you look at these three judgments in recent times, one is of course the Sabrimala judgment, the first judgment, not the review petition, where you're saying that it's an inequality in society, which says women who between the age of 10 to 50 can't visit the Sabrimala shrine, right? And how do you address that kind of inequality? Is it through a norm, which is the idea of equality, which is embedded in the Constitution, through an institutional framework, which is the Supreme Court, and the idea that a judgment of the law of the Supreme Court is the law of the land, right?
Thank you.
Lakshita, can I add something to that? And I think, in that sense, law for a long and continues to be is a strategy for feminism. But I think part of the challenge is which laws need to be changed and how they need to be changed. What would a feminist law look like? I think has to be based in social movements. It has to be from the ground up, because otherwise I think we end up in these much more narrowly legalistic institutional sets of questions and challenges and debates, which I think are really contrary to the whole point about what is our agenda. If it is about social justice and equality, then it has to be based and somehow be very directly located from those constituencies that are going to, that either have been denied or are going to benefit from it.
Thank you. That actually answers one of the questions the team had for you. With the next question, we're going to come back to dignity, and this is for Dr. Narrain. You spoke of privacy having dignitarian foundations. In light of the rejection of the link between equality and dignity, do we need to not rethink our articulation of privacy in a concept as empty as dignity?
Yeah, no, again, this is a point which I think there's a lot of literature on. And the question of, is dignity a meaningless concept, or is dignity an empty concept? It's a question which has come up again and again. But I think you have to think also from the context of this particular country, right? And why does Article 17 prohibit the practice of untouchability? And why is dignity such an important part of the Indian constitutional framework? If you look at the recent book by Akash Singh Rathore, he makes the point that dignity enters the preamble, dignity of the individual enters the preamble due to the intervention of Dr. Ambedkar. Article 17 is there because of Dr. Ambedkar, right? So in a sense, if you're talking about a discrimination based on caste, it's fundamentally dignitarian harm. What do you mean by dignitarian harm? You mean that it imposes a sense of humiliation in you. It lowers your sense of self-esteem. It makes you seem lower than the other person in the eyes of society itself. So I would push back a little bit and say dignity is not a meaningless concept. It is a very meaningful concept in the Indian context. And taking from Jyoti again, why is it a meaningful context? It's not because I'm saying so, because dignity has been invested with meaning by social justice struggles in the Indian context. Dignity is deeply meaningful from the point of view of anti-caste struggles. Dignity is deeply meaningful from the point of sexuality struggles. I'll give you just one example to illustrate this. A friend of mine recently, when the US Supreme Court judgment on same-sex marriage came out, he was talking about conversations in office or whatever, and one of his colleagues said, today gays and lesbians are getting married, tomorrow animals will get married. he said that what that fundamentally did is hit a sense of selfhood and dignity. So you get a sense of why a dignitarian harm is a very important part of a constitutional framework.
I would completely agree with everything that Arvind said. And I think there are, as I see it, there are more possibilities in terms of dignity than there is in terms of privacy. And privacy, again, it's not just a legal concept, it's a social concept. But we know that privacy is constantly being mediated and modulated by access to resources, right? Even if it is about self-expression, that we need certain kinds of resources in order to enable that. I think dignity puts, and that's constantly being, as I said, mediated by all kinds of factors. Dignity, I think, becomes a much more, it's a harder to pin down concept. It's a more challenging concept, but I think all the more important precisely because of it. What does it mean to live with dignity? What does it mean to die with dignity, right? As we are facing all of these questions so immediately and profoundly these days. And that question of dignity, I think it opens up social conversations and social understandings of what it looks like and where it is denied and what the restitution for that is. So I find it a much more promising concept, even far more promising than privacy.
Thank you. I'm going to take another question from a student who again wants to reinterpret the question and ask, can the law be feminist? That is, structurally, can the law be feminist? The way law is formulated in practice, the way courts function, the hierarchy and bureaucracy of the legal system, and so on. And I would like to use another question to contextualize this one, which refers to the Karnataka High Court judgment or ruling today, which said that how could the woman fall asleep after being raped, which another attendee has raised a similar question. So either of you can take that as well.
Yeah. See, I think the mood which I'm getting, which I think is an important one, is a sense of a dissatisfaction with the law. And I think that is true. That is true. I think we have to honestly say that in terms of the way the Supreme Court and the High Courts have functioned in this time period, it's a question of deep anguish as far as any person in this country is concerned. And everybody is right to feel that sense of a dissatisfaction and an anger. You know? There's no way out of that. And my point here is not to defend the Supreme Court and the High Court in terms of the judgments, in terms of the really judgments which they're given which betray constitutional principles. And I think the point we go back to again is we go back in a sense to the normative framework, which is the Constitution. And why do we go back to the Constitution? Because we go back to the Constitution because the Constitution is a product of a struggle. It's both a struggle against colonialism and a struggle against caste domination, and a struggle for gender equality. And so that's really the framework with which we judge a range of these the judgments which may come out, right? And so in a sense, the Karnataka High Court judgment, for example, what we have to do is we have to do an open letter on the lines of what Professor Bakshi did in the context of the Mathura rape case and expose it for the way it hollows out the reasoning of development of a jurisprudence of gender equality. So I think you have to go back to a framework of law which derives from a certain kind of from a context of struggle, you know, and that's really that's the way I'd phrase it, you know, and criticize or critique precisely the kind of judgments which your colleague spoke about.
I think the question is actually raising something important, and I'm not sure it's easily answerable in that sense, but certainly it's asking for us to come to grips with it. And this is, you know, something what I was talking about in my opening comments, and that had to do with the system of laws that exist, you know, where they come from, and that they have been put into place within a colonial context, that they are then embraced by post-colonial states, which is about, and certainly there are these principles of equality and even to a degree dignity and other, you know, important factors. But at the same time, there is the question about, you know, are we always just tweaking it? Are we always modifying it without being able to change the fundamental flaws in the structure and a kind of reasoning and a kind of symbolic system that is constantly militating against marginalized communities on the one hand, and that gives the state on the other hand a sort of almost an open check, an unwritten check to legitimacy and authority. So you can have Article 370 being revoked as far as Kashmir is concerned. And that is seen as somehow authoritative, that is seen as securitization, that is seen as Indian nationalism, right? So it's given this kind of legitimacy to arbitrary, problematic state policies in ways that I think are really part of that structure of law and part of our socialization, that if something comes from law, then it must have a certain kind of authority. It has legitimacy.
Thank you. And I think we have a slightly related question. How can we work towards existing laws inclusive of emerging identities, instead of receiving new laws which are just as restrictive as their older counterparts? And the example here is the Trans Rights Act. Could you shed some light on the process involved in pushing for progressive legislation?
Sure. I think the point which I should have mentioned and which I didn't is, one is of course Navtej as a starting point of struggle. The other is the judgment of Nalsa, where again Jyoti mentioned this. The importance of Nalsa is the fact that you have encoded in law the idea of self-recognition of gender. And you have encoded in law the idea that the freedom of speech and expression includes the right to dress, mannerisms, and attire as well. So it's a very important kind of constitutional development. But then the struggle point is really this, that post that, every bill which has come has fallen short of the Nalsa standard. Every bill which has come. And the Trans Act completely falls short, again, of the Nalsa standard of the fact that you have to allow for self-recognition of gender. And again, the question we asked our trans colleagues and friends again and again is, why did this happen? Why, especially, again, on the struggle point, is there was in city after city, this protest after protest, saying, we don't want this bill. It does nothing for our communities. Please get this act off our bodies. That was the demand from the transgender community. But in spite of that strong demand which came from the transgender community, the government passed the law. And the question you have to ask yourself is, what does this indicate of the way the government values trans lives? And really, that's the fundamental point you get, the sense of utter contempt and utter indifference to the voices of trans people in the way they've gone about formulating laws and policies. And here again, I mean, suddenly I'm on Jyoti's side of the fence. I'm saying that I completely agree with the sense of a critique you have of laws such as Transgender Act, because it's a fundamental betrayal of everything the community has really fought for.
And I think we have to ask why and when why, when, and what are these laws? And it seems to me that some of the emphasis in terms of decriminalizing homosexuality or the trans rights, these are about a certain kind of state imaginary. Certainly the push is coming from below, from grassroots, and that's important, but that the ways in which governments and state institutions respond to these things is by really, again, establishing a certain kind of legitimacy for themselves, because issues around queer or gay issues as well as trans issues have become a certain kind of marker of modernity on the international global stage. So that this is also about how India is going to look, or how some other country is going to look, and establishing itself in that way as a player within this modern framework. And therefore, it's a kind of a check. You've checked that box and you've checked that box without really any sustained attention to what is this doing to the lives of people. It may have brought a little bit of improvement, but it's also setting other things. It's making other things far worse.
And I just want to add to that and to what Arvind was saying about how the impunity with which the voices of trans people was ignored completely in the formulation of this law. I mean, I was just reminded of Gandhi when, they're talking about the bill to criminalize Devadasis and to outlaw them. And lots of Devadasis write petitions saying, we actually don't want to be outlawed. We are perfectly happy the way we are. And Gandhi famously says, well, we can't listen to them because you wouldn't listen to opium addicts who tell you not to shut down opium dens. And so the sense of pre-criminalizing the people who you are allegedly going to criminalize only after the law is sort of a very interesting interplay, I think.
Right, thank you. The next question is for Dr. Narrain. What are your thoughts on the critique that the notion of privacy that is at the core of the Nas judgment enshrines a binary between acceptable and unacceptable, private and public, good and bad, desirable and undesirable expressions of sexuality?
When we say that privacy is linked to the sphere of autonomy, it allows you to express certain parts of who you are. And I think the person who asked the question is right, because there's no right which is a free-floating right. There's no right in the in the Constitution without limitations, and privacy can be subject to limitations. So the author is right to ask the question, or the questioner is right to ask the question of saying that that how will the right to privacy be interpreted in a particular context, right? If you're talking about, for example, a kiss in a public space, how would that be interpreted in the Indian context? These are all questions which the future will answer. And again, this I think is partly to do with how the evolution of a social movement at the ground level, evolution of attitudes on gender and sexuality in a broader sense, all of this will play out in terms of how this interpretation happens. But in terms of the law, it's always possible that the law could be interpreted in terms of this falls within the domain of privacy, this doesn't fall within the domain of privacy. We've seen that in context of the wonderful judgment in terms of the Puttaswamy, but the other judgment doesn't uphold the notion of privacy and comes to the other act. So there's a way in which, we have a normative framework which is very expansive and very large, and how it's actually interpreted is subject to many, many factors.
And Alankrita, may I just add one piece, and that is, I think sometimes with particularly people who work outside of, who are not lawyers or within that industry and within that profession, I think we lose sight of the fact that law is also, as a system, as a structure, is also deeply inconsistent. And it is, it can also be irrational. We think of law as the most rational of structures, but in fact, law and legal reasoning and legal arguments can be deeply irrational, which is not to say I'm not making that claim about Puttaswamy, I'm just making that point in general. And therefore, its interpretation and its the readings and the arguments and the judgments that are delivered as a result of it, which have such profound impact, can also be very uneven.
The next question is also for you, Professor Puri, and you could actually elaborate on what you were just saying. It says, could you elaborate on the unintended consequences of laws that we create?
I'm sorry, in what?
Yeah, could you elaborate on the unintended consequences of laws that we create?
Oh, laws that we create, thank you. So, one of the sort of the work of Flavia Agnes comes to mind right away. And she and other feminist scholars have shown that even as the laws prosecuting and protecting against rape and sexual assault have increased, the number of convictions seem to have gone down. So there is this, there's this sort of sharp divide, because an unexpected consequence of that, because when you think about sort of better laws and more laws and laws that have been more thoughtfully framed and they have been increased, again trying to fill in the gaps, trying to cover all of those loopholes, in fact end up having an unintended consequence, which is, as far as we can see, a lower rate of justice being delivered. So that would be an example, and there are many such examples that have occurred over a period of time, which is why I think in terms of within feminist, within queer and trans activists and scholars, there is a certain amount of skepticism around engaging with law. And again, you can't sidestep it altogether, but there is also this this understanding that legal activism comes with costs and consequences.
Can I just comment a little bit on that point? And I think I take the point well about the skepticism with respect to the role of law, And part of the response to that is, I think it's very important that we don't see law as the sole answer, and we don't see law as not the answer either. So there's a way in which we have to think of the law and I think going back to Jyoti's point, actually, we have to think of the law and the social movement as really two strands of a double helix, as tightly intertwined together. That movement in one leads to change in the other. I'll give you maybe one illustration of the way we thought about this, at least. In the context of the 377 struggle, it was always a social, legal, and political struggle. It was never a legal struggle alone. It was a struggle in the courtrooms alone. Then the success would have been very limited, And the success has really been, how has the struggle in the court been used to transform attitudes at the level of the ground? Give you one illustration. One of the interventions which was filed post the 2013 judgment was by parents of LGBT persons. And that was, I thought, a very moving and very important intervention, because what it did is we had parents on Barkadat's NDTV show basically making the point that we have parents who have gay and lesbian children, and we are filing this intervention because we believe that 377 is a fundamental attack on family values. Because of 377, we feel that we're not able to have these conversations with our children, because the children, the sense of selfhood is confined by this law. They're scared to express themselves, and we're very terrified that when they go out, they may not come back, or they might be subject to police violence, harassment, etc. And so the fact that this played on primetime TV is a way in which you're using, right, the fact of a struggle which is rooted in the law to really transform social and cultural attitudes. So I'm 100% on the point that we have to use the law to make a wider transformation. At the same time, I think that it's a very important, and go back to my point, is I think the law is a space for struggle. And again, going back to the argument in the Constitution and the colonial regime, the point I'd really make is this, that there is a part of the what we'd call a regime of colonial continuity, which is the Indian Penal Code, the Criminal Procedure Code, etc. And sections like 124A and sedition. These are clearly parts of colonial continuity. At the same time, we have provisions which are very important, which we have to acknowledge, which are Article 15.2, Article 17, Article 23, which are really about, the prohibition of the practice of untouchability. If you go back again, untouchability was not an offense in this country. It's only post Article 17 coming in that we've taken the position that it's a social practice which we condemn, which make a criminal offense. Article 15.2, which says that you can't deny a person the right to access a bathing guard or a restaurant or a shop based on caste or gender. And that's again a very important advance in our ways of thinking. And again, going back to one more feature of law, which is not the Constitution, which is pre the Constitution, which is actually the Indian Penal Code. There's a very fascinating discussion on the draft penal code. And Dr. Ambedkar comes in on one of the perhaps the most banal provision. He comes in on the idea of the word person. He says it's a very important innovation. He says because in India, fundamentally, all persons are not equal as far as the criminal law is concerned. You're treated differently based on caste and religion. So the fact that this penal code has the word person is an important advance of modern law, in terms of the fact that you're going to treat everybody equally. Again, this is at the level of the norm, while taking on board completely Jyoti's point in terms of how the structure might finally operate out.
And a very quick thing to add to that, and I think here, the cases in terms of caste discrimination or sati, these are important cases in terms of where we see legal change setting a certain tone for the rest of society. But for these to have any meaning, for them to have any traction, really means the hard work on the ground. Otherwise, these laws are just what they are. They're empty. They do not have any great impact in terms of the social fabric. And I think, so I completely agree with what Arvind is saying in terms of law is one aspect. It's an important aspect. It needs to be, held together with social movements and so on and so forth. But I also think we need to, for social change, we need to think beyond the structures of law in terms of other kinds of mechanisms that are going to address the problems of social injustice and allow us all to live lives of dignity.
Thank you so much, Arvind and Jyoti, not just for your brilliance and your perspicacity, but also for modeling for us really rigorous and ethical ways of agreement and disagreement. And long, may that spread far and wide. I just want to say that that the recording of today's session will also be available on our YouTube channel for those of you who might want to watch it again, or for those of you who have friends who have not been able to watch but can then go back and watch it later. And we'll be back next week with a slight change of day. We'll be back on Friday rather than Thursday. We'll be back Friday, July 3rd at 7 p.m. Indian Standard Time with a session on politics with Atharzia and Papuri Bora. Of course, all our sessions have been on politics, as you've heard, but this will be explicitly on that. So see you all next week. And all that remains for me is to thank Jyoti and Arvind for really getting us in the mood for thinking about the law seriously. Thanks very much. Bye to everybody.
Madhuri, thank you. And thanks to your wonderful audience, who I'm sorry I couldn't see, but thank you.
Thank you.
Thanks, Arvind.
Thanks. Bye.